Uh-oh.
If I took one of them, I couldn't function.
What are...
Do my next
I guess... I'd like to call the Industrial Relations Committee to order. Good morning, everybody, and welcome to the Capitol on this off day. But thanks to the members of the committee for coming in. I appreciate your time and participation. And again, welcome to those who are here for the first time. We appreciate your involvement in the governmental process. We've got three measures that we want to take up today and discuss, and we'll just get started if that's okay with everybody. We did have a sign-up sheet for these three measures. If there's someone out who would like to sign up, please raise your hand, and I'll have the aide go up. Otherwise, I think we have a good list. Okay, go out and get that. Let's take up the resolution first. It's House Resolution 1561. House Resolution 1561. You members, you should have a copy in your folder. Representative Shaw. Is Representative Shaw here? And we also have our Agriculture Commissioner, Gary Black, is here. Mr. Black, you come on up too. We appreciate you coming to our committee meeting. Our constitutional officer, thank you. Representative Shaw.
Thank you, Mr. Chairman, members of the committee. We're here today to talk to you about House Resolution 1561. This is an urging resolution dealing with some proposed changes coming down from the federal level with the Department of Labor that we feel are very overreaching and could have major impacts on what our way of life in Georgia, and especially in our agriculture and agribusiness industry. The proposed changes coming down from Washington are dealing with the changes that would basically prevent children under the ages of 16, and then for other jobs under 18 from working on family farms. And the reason I'm here to talk to you today, because I grew up working on our family farm, and these changes would basically, if you've got a farm that's a corporation or an LLC, which in today's ag environment, most farms are incorporated. It's not, the farming is not like it used to be to start with. It's not like you're raising a bunch of chickens in the backyard and getting some eggs. I mean, this is a real business, and we all know it's the #1 industry in the state of Georgia. But if these changes or the proposed changes are enacted, I'll use myself as an example. I mean, every Saturday I was working for my grandfather on the family farm. These changes say you cannot work for your grandfather. You cannot work unless you could work for your father, but you couldn't work for your uncle or your grandfather. But if you were under 16, you couldn't even work for your father on the farm. Now, we're not just talking about safety here. We're talking about affecting, I mean, like I said, I wouldn't be standing here in the man that I am today if I didn't grow up from my experience and learning the value of hard work, growing up working on a farm. And that's what this would do. And we've already got a problem in society now with, sometimes I think we would all agree that our young people maybe don't work quite like they used to when we were all growing up. I mean, I'll use my hometown as an example. Now we go back to school, 1st of August. Used to, we didn't go back to school until, and I'm not that old, y'all, but we didn't go back to school until after Labor Day in Lanier County because we were still cropping tobacco. And you don't even, now everything's automated, but at the same time, there's still work to be done on the farm. And if we take that opportunity away from our young children and that opportunity to learn what it means to work hard and in this case, feed our families, I don't know what would happen. And you also got to realize that this would affect our ag education programs in the state. I mean, we've got 285 FFA programs. I was president of FFA in my hometown, went to the national convention in Kansas City. Everything I took away from that experience is again helped me to become a better person. These laws would change all of that. So we just want to send a message to our partners in Washington. And a lot of this is coming from a former congresswoman from California who is now labor secretary. She tried to do all this when she was in Congress. She attempted it when it was a Republican-controlled Congress and when it was a Democrat-controlled Congress, and it didn't get anywhere. Now she's trying to do it with rules and regs coming down from the Department of Labor. And if we allow this to happen without at least doing everything we can from the state level to say, hey, this is not going to work. This is all we're trying to do is send that message, and hopefully that it will have some impact, that they will rethink some of these ideas and realize the impact that it can have. But I really appreciate the time this morning and the opportunity to just tell you what's going on, and I hope you'll agree with us that we can't let this happen to us here in Georgia. Thank you very much. And
okay.
With that, I think the Commissioner Black would like to add a few words as well. From
Okay,
his
let's let
standpoint.
the commissioner speak, and we do have some questions, so I need you to come back.
Mr. Chairman, members of the committee, thank you
Yes,
for
sir.
letting me be. First, what we don't want to do is overkill an urgent resolution, and so I thank the committee's indulgence to just to speak a quick word. I'm reminded, I interned on Senate Agriculture and committee in Washington when I was a senior at University of Georgia, and Senator Herman Talmadge was chairman of that committee, and I learned a lot from him and always admired his advocacy for agriculture his entire career. And of course, his daddy had a rich heritage here in Georgia too, but also held the office that I am in now, and so it's interesting to see. But I'm also reminded of what Senator Talmadge once said. Somebody asked him what he thought about Hubert Humphrey when he was running for president. And I always, he was always a passionate guy, and I always liked his enthusiasm. But he said, well, you know, Senator Humphrey's a great guy, but says, I'm afraid, y'all, that he's one of those kind of fellows that's got more answers than there are questions and more solutions than there are problems. and that was the kind of he framed, that kind of framed his career. We've got an answer from a federal agency that's a solution that's looking for a problem. This is wrong. It is wrong-headed, I believe, when we have someone be secretary of a federal agency who was in Congress that tried to basically never got a hearing on a bill. Sponsored legislation, never got a hearing, but now trying to implement it as policy. I don't care which side. This is not, to me, this is an agriculture issue. It's not a partisan issue whatsoever. It's a matter of what's good for agriculture. You give me a young person, like my children, 9 and 11 years old, when they were 9 and 11, they went in the barn every morning at 6:30 because they showed cattle. You give me a child and you put them on the end of a halter every afternoon, we can stop some of the problems we're having with our young people. They need more responsibility. And the very notion that a 14-year-old child couldn't rake hay for his uncle, couldn't drive a tractor. When my daughter was 12 years old, she drives better than my 25-year-old son now. I mean, she in the hayfield and doing those kind of things, she could do better at 12 than my 25-year-old son does now. So it's just, and that's a little hand-eye coordination deal there, but it's very important. Again, don't want to overkill an urgent resolution. We know how those are, but I appreciate y'all hearing it. It's very important that we send a message. I don't care what. This is not an administration issue. It's from a standpoint of who's there or what. It's bad. This is bad for agriculture, and it's bad. We need the federal government to work on problems that are real problems, because this is not a problem. And I thank you for hearing me today. Thank you, Mr. Chairman.
Thank you, Commissioner. We have a couple of questions. Representative Hagler.
Yes, thank you. Representative Shaw, I have just a few questions. This does apply to families, correct? But this is the bill. Anyone that works under the age of 18?
Yes.
I'm just asking. But anyway, I learned how to drive a tractor at the age of 12 years old, and it did me some good. And I think that anybody in my house has to work wherever I tell them to work. So this just being said,
That's right.
do you think it's hazardous for my 9 and 10-year-olds to hold signs on the side of the road when I'm running for election? I'm just asking. That might be dangerous.
I certainly hope not, because mine will be doing the same thing if I'm still up here when they're that age.
I'm just checking. But I want to thank you for this, because I think that in this area that the government is overreaching their stretch. And at the appropriate time, I do want to make a motion. But you know,
We got one more, another question.
Thank you.
Representative Kaiser.
Thank you, Mr. Chairman. I actually just have a statement as well. I had the opportunity through Leadership Georgia and as a legislator to go to Moultrie and Camilla, Georgia. I milked a cow with Amy Carter, and I realized you don't really manually milk cows anymore. I live around the corner, so I'm an urban legislator. But, you know, you really honestly could make the argument that these kids, you know, we have a shortage of math and science teachers. And the way that they farm now, I was amazed that you really could make the argument that we have future engineers, math and science people coming off these farms as well. So I support this fully.
Thank you.
Excellent. Any other questions from members of the committee? Any other questions? Is there anybody else out there who would like to speak for or against this measure? Anybody else? Anybody else? Okay. Commissioner, thank you for coming. Jason. What's the will of the committee? Representative Hagler?
I move that we do pass this House Resolution 1561.
We have a motion. Do we have a second? We have a motion to second. Is there any other discussion by the committee? Any other discussion? All those in favor of the passage of House Resolution 1561 signify by saying aye. Aye. Anybody opposed? The ayes have it. House Resolution 1561 moves on to the Rules Committee. Thank you. Thank you, folks. Okay, next, let's move on. House Bill 432. House Bill 432, Representative Dempsey. Representative Dempsey, good morning. Thanks for coming today.
Good morning, and thank you, Mr. Chairman and members of the committee. I appreciate y'all being here today as we get ready for the final big day tomorrow of this point of the House's responsibility. I think most of you were probably here last year when we presented this bill. If you've heard it presented in committee last year, could you just raise your hand so that I'm aware of it? Okay, I'm going to be brief then, because I know everybody's got many things to do today. This is a realistic, cost-effective policy. The Family Care Act is currently on the books in 8 other states, and it will allow employees to use whatever sick day policy is offered by their employer to care for an immediate family member. The focus is very, very narrow. It's not for your extended family. It is for your child, your husband, or your own parent. The bill does not mandate any particular sick day policy. It does not require employers to provide additional days or even any days at all. A group of very concerned citizens in Rome came to me and asked me to look at this concern that they have. The director of a women's shelter, members of a service organization for people with disabilities, and also local members of the American Association of University Women. They tell me about people that they serve who are struggling to provide for the health of their children and disabled family members particularly, without flexibility to use their own sick days to provide care. State law requires parents to immunize their children in order to attend school, yet we do not always allow them the time to take off to go and do that. This is a win-win bill for families, for employers, and for communities. It's very responsible to not spread diseases in our schools, particularly in nursery schools. I have 2 little granddaughters, and every weekend when I visit with them, I start sniffling immediately because they are dealing with all of the germs that go around that I'm not used to. But anyway, for a parent to be able to stay home and to take that child to the doctor or to address the medication issues that they may need at that time is so important, and it helps our schools. It's also a business benefit when employers cannot afford today to give raises, to increase other benefit package to employees, to develop this wonderful gift, I think, of transparency and honesty between the employee and employer that says, you don't have to lie to me. Your child is sick. Your parent needs you today. I'm not going to let you have any more time. And if you get sick later, it's going to be not under our current policy. You're going to lose pay for that day probably if you use up all of your sick policy. So to allow that honesty to go on, I think, is so important, and it's a benefit that is hard to measure in dollars, I do believe. When you heard testimony last year, you heard from both a large and a small employer, both who said the great benefits that had come from this. I want you to know that we're going to hear some testimony, I'm sure, from those who oppose this bill, and I certainly respect their own feelings on that and the constituencies that they represent as well. My family business is small and getting smaller every day in this economy. It's down to, we've moved 3 times in the past year, actually, to get into a smaller and smaller and more affordable office space with fewer and fewer employees. But we are loyal members of the State Chamber of Commerce, and we will remain that way, very active in our local chamber. On this issue, I think that we have agreed to disagree, that I see there is a need. It comes from local people who feel that it is very important to their cause. I want to bring before you an amendment today to add to this bill, if this would be the appropriate time to bring that up.
You should, the members should have the amendment in their folder. It's AM 370155.
Right. We particularly did this to address strengthening and clarifying that it does not require any company to have a policy. So if you will look on line 20, we would delete and add the following language. Nothing in this code section shall be construed to require an employer to offer sick leave of any kind, however, and it moves forward from there. We did this particularly to make sure that it does not become a mandate, that it is clear that it is not requiring any business to create sick leave. Also, you will hear concerns, and I believe strongly that we remain a state who supports employment at will. If you'll look on lines 25 and 27 in the bill, it specifically states, reserve all rights of employers to fire at will with the narrow exception of the family care leave. Our language is the same as the Georgia Code language that protects an employee's ability to take time off for jury duty or subpoenas without fear of disciplinary action. Family responsibilities. We're giving those family responsibilities the equal protection that they deserve. Today, we have a few people who are here that would like to testify, if that would be
You had a
appropriate.
question, Representative Horn. want to
Yes.
ask you questions.
Yes.
Thank you. Thank you.
Mhm.
My question is oftentimes, well, maybe even all the time, the employment is a contract between the employer and the employee. Are we not interfering with that with this legislation? Because this bill applies to private companies, correct? I mean, this applies to every company in Georgia that does business.
It
as
does
an
apply
employee.
to anyone who has a sick leave policy. You know, I would say that we're interfering in the same way that we require our children to have shots, and we don't allow those parents the time to go and do that. I know in my local community, when I was on our city commission previously, we instated a policy within the local government that parents could, on the first day of school, take time off to go walk that child into school to be there to meet the teacher. Now, a lot of businesses don't even allow that. We did a radio campaign on it to encourage other businesses to do it. I think we can encourage. You're absolutely right. We could stay out of it, but I think it's equally important to the fact that we're requiring parents to do certain things. And I just think it speaks so to the transparency and the employee-employer relationship that is important at this time.
Okay, we do have quite a few folks who want to speak for and against the measure. Let's start with the supporters. If you just be brief, is that okay?
Absolutely. There are two particularly that if it would be appropriate to start with, and then the others will be very brief.
Okay.
Would that be okay?
That would be great.
Beth English, first of all, is the Executive Director of Easter Seal Southern Georgia, and then Pat Willis, the Executive Director of Voices for Children. If we could start with those two, and then I'll be back if y'all have any further questions.
Okay. Now, Ms. English, if you'd come forward. Again, just tell us who you are and who you represent.
Thank you, Mr. Chairman and members of the committee. My name is Beth English. I'm Executive Director of Easter Seal Southern Georgia, and I'd like to bring briefly three perspectives to the committee on this bill. I'm a community volunteer. I've been a member of the Georgia Federation of Women's Clubs for over 30 years, and I've been for the last 4 years their Legislative and Public Policy Chairman. There's over 108 clubs with over 3,000 members in Georgia, from Augusta to Albany, from Cochran to Calhoun, from Blue Ridge to Brunswick. These women volunteer in their communities. They're Republicans, they're Democrats, they're independents, they're homemakers, they're teachers, they're retirees, they're mothers, they're nieces, they're granddaughters, they're aunts. They're all different, but the one thing they have in common is support for House Bill 432, and we have a letter to that effect. They support it because it supports public health, because it strengthens families, and it's simply the right thing to do. The second hat, which I'm wearing today, is that of disability advocate. For 34 years, I've worked in the field of supporting children and adults with disabilities. The last 20 as Executive Director of Easter Seal Southern Georgia. We actually served in 2011 3,000 children and adults in 60 South Georgia counties. This bill is very important to Easter Seals and to the families it serves. Many of our children are medically fragile and have special needs that require mother or father to be able to take them to medical appointments, to specialized appointments. And so the flexibility that allows mother or dad to take time to go to these appointments, is so important because these families want to continue working. They want to continue being taxpayers. They want to continue to take care of their family member at home. And then finally, I'd like to speak as the CEO of an $8 million business operation. Easter Seal Southern Georgia has an $8 million budget with 255 employees. We've always had a flexible family sick leave policy because it makes good sense. When you have employees who feel that they are valued and that you invest in them, maybe not so much in salaries because my staff haven't had raises in 3 years, but because they can take time to be with that sick child or to be with that grandmother who has Alzheimer's that you're caring for. It's resulted in a much more stable workforce, a lot less turnover, and a higher morale. In many occasions, my key staff have actually turned down positions at higher pay because of the family-friendly work environment. So I would encourage this committee to please pass House Bill 432. It's critical for Georgia families. It's good for economic development.
Thank you, Ms.
Thank
English.
you.
Thank you. Who next? Just tell us who you are and who you represent.
Good morning. I'm Pat Willis. I'm Executive Director of Voices for Georgia's Children. Thank you all for the opportunity to speak today. Thank you, Representative Dempsey, for sponsoring this. As the CEO of a nonprofit, I am an employer. I'm also a member of the Georgia Chamber of Commerce, and I'm a member of the Georgia Chamber Board. As child advocates, Voices supports House Bill 432 because it's good for children who have no caretakers except their parents when they are sick or need to have a medical exam. Exams that are required to enter school, in many after-school programs, and also for athletics. Schools and child care centers, if kids are sick, they will send them home. They could be sent home to an empty house if the parent isn't able to be there. As an employer, I support House Bill 432 to ensure that kids stay home when they're ill and prevent those cycles of infection that seem to run in communities. Sick kids in school infect teachers. Teachers infect their own families. Their own families are your employers or employees. So redefining sick leave under the law will affirm what the state of Georgia and most employers already do. Furthermore, it reinforces our expectations of parents that they will take care of their children. They will take care of their children, not somebody else, not the government, not the schools. And it will send a signal to employees that Georgia is a family-friendly work environment. I urge you to vote for House Bill 432. Thank you very much.
You had a question, if you'd like to take it. Would you
Sure.
like to take a question? Representative Horn.
I just have one question. You're an employer. Is your company's policy that you allow your employees
Absolutely.
to? It is. So
Yes.
you're doing that without the law?
Yes, sir.
Okay. Thank you.
If Voices for Georgia's Children doesn't set the example, who will?
Okay. There were some others who were in support. Linda Lowe. If you want to speak, you would like to come forward.
I just want to say that Families First supports it. I don't need to take more time.
Okay, that's perfectly great. We also had Shelley, Senator.
On behalf of the Georgia Coalition Against Domestic Violence and Georgia Women's Lynching, we also support it. We won't take further time.
Okay, Representative Dempsey, I'll just let you be the coordinator on this if you like. Yeah, but if you'll just identify them and have them. Who else do we have? Did anybody else sign up? Okay. If you'll please go up and just tell us. We want to keep it on record and keep it official and put you out on the internet so everybody can see you.
Great, thanks. I'm Pat Novy. I'm the Deputy Director of the Georgia Council on Developmental Disabilities. We're a statewide organization that does systems change, capacity building, and advocacy for people with developmental disabilities. We support the bill for the same reasons that Beth English so nicely detailed. Parents that are raising children with disabilities often have to drop everything at a moment's notice and get to the hospital or get to a medical appointment or just stay home. So we support the flexibility in this bill and appreciate your favorable consideration. Thank you.
Thank you for coming today. Yes, sir. Come on up and tell us who you are and who you represent.
Thank you, Mr. Chairman, members of the committee. My name is Wendell Phillips. I'm the public policy advocate for the Presbytery of Greater Atlanta, which is a governing body of the Presbyterian Church USA. And we're simply very pleased to be able to add our name to those who support this legislation, and we look forward to your passing it. So we urge you to do so. It's a very good bill, and we concur with all the testimony you've heard in favor so far.
Thank you, sir. Is there anyone else? Would you? Okay.
I'll be brief as well. My name is Nancy Petra, and I'm the Senior Citizens Advocacy Project Coordinator for the Georgia Council on Aging, the Georgia Gerontology Society, as well as the Georgia Area Agencies on Aging. And we just want to show our support for this legislation today because we work with a lot with people who are staying in the workforce a lot longer, so they end up taking care of spouses, and they need the time off for that. And for that sandwich generation, who may be me one day, who's going to have small children as well as maybe a parent in the home, and you're going to have to juggle all three, and you still want to be able to continue to be a taxpayer and stay in the workforce. So on behalf of those individuals, on behalf of what else, all the testimony you've heard, we support this initiative as well.
Thank you. Anybody else? You can work your way around there if you'd like. just please tell us who you are at the podium so we can have it official, okay?
Good morning. I'm Carolyn Pinkston, and thank you all for giving me the opportunity to speak this morning. And this here has come from myself with Family Act 432. I'm with the 9 to 5 that I'm with, and this right here is very important to me because I remember the time that I had to have surgery. I had to have brain surgery, and during that time I had my daughters, and they could not come up to see me during that time. And then I had to have radiation. The same thing happened. And I know this is very important for me to have my daughters there, you know. And it was very important for me to have them at my side. And I think it was very important for I got to see other mothers that had young children, and they could not come. They had to leave someone else in their place because I knew that they had to be back to their job. So it's very important, you know, for me. And even though I have to go through a little things back and forth, and I know that it's important to those, you know, to have the ones there for them. And I really appreciate you giving me the opportunity, but it's, you know, they need this for their families. The children need their mother and fathers there, and also the adults also need their mother and fathers there. So
thank you very much. Thank you for your testimony. Okay. Anybody else supporting the measure, House Bill 432? Anybody else want to speak? Okay, we do have some folks who are opposed to the measure, and we'd like to invite them up. David Rayner, the Georgia Chamber of Commerce.
Thank you, Mr. Chairman, members of the committee. I'm David Rayner with the Georgia Chamber of Commerce. And first, I'd like to state that on behalf of the organization, we certainly sympathize and we applaud Representative Dempsey for her passion on this issue. And we thank her for allowing us to have a seat at the table as we were negotiating over this piece of legislation. I guess I would say that from a policy standpoint with the Georgia Chamber of Commerce, one of our cornerstone issues that we continue to deal with is strengthening our right to work status and opposing any attempt to erode our employment at will doctrine, which is really our greatest economic development tool and job creating tool we have in this state. So if it is the will of the committee to move this measure forward, I would draw your attention to subsection D, which I believe Representative Dempsey did include in her remarks, with dealing specifically with disciplining or discharging an employee were they to act in accordance with this law. I would just ask that the committee really take a look at this subsection and the potential for maybe striking it out, because once we look at chipping away at our employment at will doctrine, where do we stop from here? And again, I can't reinforce enough just how important it is that we keep that employment at will doctrine in place. So again, would ask that you would consider any amendment that may be able to strike subsection D out of the bill, and I think that would go a long way to address some of the issues that our organization has with the legislation before you.
Did you have a chance to look at the amendment?
I did, and actually Representative Dempsey shared it with us yesterday, and we see that it just reinforces, I think, what's already stated in subsection B on line 20, that an employee that provides sick leave, so it's already addressing those employees that already provide sick leave.
Okay. Any questions for Mr. Rayner? Thank you.
Thank you.
We did have a question.
Question. I just want to ask, you may or may not be able to answer this, but do you have an idea of your members? Do they already do this? Do you know?
We have never really realized.
I've employed people for a small company and for a
Right.
large company, and I know that as an employer, I would always try to work. If I had good employees, I wanted to
Right.
keep them. I would always try to work with them if
Right.
they needed.
We
to
have
go
not
or something.
heard of any instances along these lines. I'm not to say that they don't occur. I'm sure they may occur, but again, I think to your point earlier, that when we have the legislature, that does insert itself in between the employer-employee relationship and the negotiation of the benefits package, then that tends to be an issue as well.
Thank you.
Thank you.
Yeah, we have another question for Ms. Rayner.
Thank you. Thank you for coming. Thank you, Mr. Chair. When you said strike all of D, do you mean all of D, even the part that says shall prohibit an employer from taking employment action against an employee for taking leave that is not protected? Because this basically, I'm from what I'm reading,
Right.
it gives the employer the right to still dismiss someone. Or are you talking about the second part of Part D? I'm just trying to get clarity.
Yes, I'm sorry. It would be, however, an employee may not discharge, demote, suspend, discipline, or otherwise discriminate against an employee.
Okay, I just need to see what you. Thank you.
Thank you.
Okay, we do have someone else who is opposed. Mr. Jackson? Just tell us who you are and who you represent.
Thank you, Mr. Chairman. Kyle Jackson. I'm the State Director for the National Federation of Independent Business. We represent about 7,000 small employers here in the state of Georgia. All around the state, folks do just about everything. Most of my members have fewer than 10 employees and do less than $1 million a year in gross sales. The reason we oppose the legislation is certainly not the underlying goal. I would argue that most of my members are already doing this today. I grew up in a small business family. I can tell you that the key to any successful small business is employees. And good small business owners view their employees like a second family. And my folks, everybody I've talked to goes above and beyond to accommodate schedules for things not even included in the legislation. Employers, small employers, want to be as accommodating and gracious to their employees as they can, because the most valuable asset to any small business is their employees. So for that reason, we think the bill is unnecessary. Appreciate again what Representative Dempsey is trying to do, but at least for my membership, the bill is unnecessary, and I think it gets us on a slippery slope of interfering with employer-employee relationships.
Okay, any questions for Mr. Jackson? Any questions? Thank you, sir. Thank you. Okay, anybody else out there who wants to speak about House Bill 432 in favor or against it? Representative Dempsey, if you want to come up and just wrap things up before we ask the committee what they would like to do.
Thank you again for this time. Two things that I think were important that were just stated in testimony. I believe NFIB, if I understood Mr. Jackson, most employees are under 10, so they would not even be affected by this measure. They're not even a component in it. The other is that if we do amend this and take that language out in there that is so important, we are creating a right without protection. And I think that each of you know what happens when we do that. It's difficult. I understand the concerns to remove that language. But in effect, we're saying, go do this if you want to. So thank you so much for the hearing. I hope that you will vote to support it and help the families and the employees and employers of Georgia. Thank you.
Okay, anybody else? All right, let's take a look at the amendment first. This is the amendment that everybody has. AM 370155. What's the will of the committee on this amendment? We have a motion. Do we have a second? Okay. We have a motion to amend. Is there a second? This is the amendment. We have to vote on the amendment first. We have a motion and a second. Is there any other discussion? Hearing none, all in favor signify by saying aye. Aye. Anybody opposed? Okay, so we've voted the amendments. Okay, now we move on to the bill itself. Okay.
I move to amend by removing subsection D and renumbering.
All right, explain to us what you're doing here.
Just respecting the fact that the law in the state of Georgia is at-will employment anyway. I don't think this adds anything to the bill, and I understand I'm a sponsor. But it does speak to me that we are an at-will state. So I would move to take out section D and renumber.
Okay. Okay, we have a motion on the floor to remove section D. Is there a second? We have a motion and a second on removing section D. All in favor signify by saying, or just let me have a hand count. All in favor? Yes, sir. Yeah, sure, we'll have discussion.
We have the lines 4 and 5, Representative, and then to be changed to on the bill with that amendment.
pull your microphone around. And
All right. Can I amend Representative McKillop's amendment to strike on line 4 from the word to, or the clause to provide that retaliatory actions are unlawful? So he essentially with his amendment, he removes that provision in the bill.
I understand. Okay, we still have the amendment on for a vote, and we need a hand vote. All those in favor of the amendment, raise your hand. 1, 2. Those opposed, the amendment fails. The amendment fails. Okay, Representative Hagler.
Okay, but I also want to do an amendment. I want to go to the same section D and take out the second part that says, however, an employee may not discharge, demote, suspend, whatever. All that.
Help me out again. Where do you start?
The second part of D.
On 27?
27.
Line 27? Okay.
You see where I'm starting and how?
I do. Okay. All right. Do we have a second for her amendment to remove that? Do we have a second? Do we have a second? We don't have a second. Motion fails for... Okay, so we have the actual bill itself with the amendment, AM 370155. Representative McKillop.
Move to pass.
We have a motion. We have a second. All those in favor signify by saying aye.
Aye.
Those opposed, no. The ayes have it. House Bill 432. House Bill 432 will move on to the Rules Committee. Okay, thank you very much. We do have another measure. Representative Kendrick, if you'd come forward and tell us about, for all those who are here, we do have another measure, so there's still business taking place.
Good morning, members of the committee. Mr.
Good morning.
Chairman, thank you for this opportunity. This is HB 780, and what this bill essentially does is it prohibits employers from doing pre-employment credit checks on individuals purely based on their credit. It doesn't have anything to do with their criminal background, but one of the reasons for bringing this is I go on listening tours before each legislative session, as I'm sure you do, and I represent DeKalb and Rockdale counties. And some people came up to me afterwards and stated that one had applied to be a bagger at a local grocery chain that shall remain nameless, and another person applied to be like a flower arranger, sort of in the bag, not handling money. And they were denied employment, and they came to find out that one of the reasons, or the reason that they were excluded from employment is that when they went to apply for this job, one of sort of the standard requirements in the stack of paper that was given to them was authorization to check their credit. And so they were were more than a little dismayed that even though their jobs didn't have anything to do with handling money, it wasn't a fiduciary duty, that they were automatically excluded from even going further in the process and towards seeking employment. And Georgia has one of the highest unemployment rates, even though it's good for a good for business state. And so I bring this measure to help further our employment rate in Georgia. And I just want to be clear. I'm a business attorney. I represent small business owners. I'm a business owner myself, and so it's not something that I'm doing lightly. But it seems unfair that people are automatically excluded from even furthering in the interview process towards employment simply because of their bad credit. There is an exclusion in the bill for a bona fide occupational reason. I totally understand if financial institutions have to do credit checks, or you're in a fiduciary duty. But in circumstances where you don't have that bona fide reason for doing so, and you're just putting an application into a stack of papers to do credit checks, hopefully you can see why that would be problematic. Now, there are 4 states that already have these laws, 17 others, and D.C. Have proposals as well towards doing for that. And you know, you can understand the reason for doing these credit checks to screen job applicants. And as a business attorney and a business owner, I don't have a problem with that concept. But when it's used to unnecessarily sort of exclude someone from even furthering in the employment process, I think then we have a problem with this bill. Especially when we have such high unemployment rates and foreclosures. You know, I'm a big anti-foreclosure advocate as well. It doesn't seem fair that in this economy somebody loses their job, they go through foreclosure, they go through bankruptcy, have all that on their credit, and then they turn around and try to get employed, and they have that on their credit only to be turned down in the initial process and not able to get employment. I mean, it just repeats the cycle over and over again. And I also want to note that just because you have bad credit does not make you a bad employee, just as having good credit doesn't make you a good employee. And so to have that correlation unnecessarily, I think it needs to be addressed. There are some bills on the national level that have been proposed to address this as well. There was, in Illinois, this has already been passed as well, and it includes police, or it excludes police, financial institutions, and insurance companies and others in the specific Illinois state bill. But the reason that it's drafted, my bill is drafted that way, is to give a little more broad discretion for employers if they have a bona fide reason for doing the credit checks, that they're able to do so. So I will take any questions or clarify anything.
Okay, yes, you do have a question. Representative McKillop.
Thank you. Thank you, Representative Kendrick, for bringing this. I myself am a sole practitioner, attorney, legislator, which also puts me in charge of a nonprofit, although not by choice.
Right.
In Georgia, you know, we're an at-will state. Do employers who decline to hire an applicant have to give a reason at all?
No. You're talking about under current law or under my bill?
Well, I mean, here it is. It says, it shall be unlawful for an employer to fail or refuse because of.
Mm-hmm.
And so what I'm asking in all seriousness is this is a remedy of not allowing someone not to hire someone because of a credit report, but there is no because of in the employer-employee relationship, that is, or the employer-applicant relationship. You don't have to give a because of, you simply decline to hire them. And so my question is, my question is this a real remedy to the problem that you're trying to solve? I mean, it would, not that I would support the bill either way, but wouldn't it be more appropriate to say you simply cannot check someone's credit on application? That is, you don't have to give a reason why you didn't hire someone, isn't it true? And so the problem you're looking to solve might be more appropriately solved by simply making it illegal to check someone's credit, since you don't have to give a reason why you didn't hire them anyway, isn't it true?
I actually agree with that.
Yeah.
And the way that this process is going to work is, you know, they wouldn't have to document or give a reason as to why they did a necessary credit check. You know, the burden would be on the, I guess, the applicant to say if they were wrongly, their credit check was wrongly checked on them, they would then have to bring suit. So it's not like they would have to document, the employer would have to document why they're doing that credit check on the person. If that clarifies or makes
How do you
sense.
prove why they didn't hire someone? Could have been 4 or 5 reasons, including a credit check. How do you? I mean, when you talk about this, you're creating a cause of action by an applicant who was declined against a prospective employer who declined to hire them. How do you prove, under your bill, why?
Well, if the employer comes up with not only a bona fide reason for why they had to do the credit check, or either if there's something else, maybe it was a criminal background check, maybe you know, they just didn't do well in, you know, in presenting. If they have another reason that they give, then obviously the credit check wasn't the sole reason that they didn't get the job. How would they prove that would be a more lengthier conversation than maybe you want to have right now. Yeah. But you know, employment law is probably one of the most litigated areas of law because it has so much detail and things that are involved in it.
And I appreciate that, and I appreciate you bringing the bill. And I know we're hearing only today, but just for future discussion of the issue, I would just be looking, if it comes back before this committee, for if you're going to do something like this, I'd like to see it in a form that actually creates a remedy for the wrong that you're seeking to redress.
Mm-hmm.
Thank you.
Representative Hagler.
Thank you, Representative Kendrick. Are you amenable to amending it if I were to make an amendment?
I certainly am.
Let's say I were to say it shall be unlawful for an employer to conduct a credit check unless the credit history or credit report directly relates to a bona fide occupation, qualification reasonably necessary to the normal operation of that business or enterprise.
I'm amenable to it.
Okay. So I would like to make an amendment to her.
Let's do this. We've got some
Or
other
send it back
folks.
to- okay.
Yeah, we're just going to do the hearing today because I do know that there's some other issues. So, but we want to work with you, and Legislative Council is here today. So if we'll get that amendment to the bill so that we'll have it ready. So if you'll, Sean Marie, if you'll make that note. Did you get everything that she said about amending it? Okay. Okay. Any other questions? I know that I'd just like to speak to, I had positioned small business person myself. I like the word not for profit in this legislative cycle. But I had posted a position for a administrative assistant, just somebody to deal with the day-to-day things while we were down here at the Capitol, and had, in just 1 week's time, had 55 resumes submitted online. And it was just a small job posting that I put on the Chamber of Commerce website. You know, the thing that I found that was so interesting, I didn't even think about the credit. I was just trying to find somebody who had, you know, the skills, the analytical and detail skills to help me out while I'm down here at the Capitol. And that was the difficult thing for me going through all those. There were so many people who were so overqualified. And I guess it goes to speak to this environment that we are in right now. You have people that are well qualified, overqualified, just trying to find work. Mm-hmm. And certainly, you know, you don't want to discourage those folks. It was overwhelming for me. One thing that I found, I tried to respond to everybody. I had one lady call me, and she was very upset because I had 55 people that I had to respond. She was upset because I didn't call her back fast enough to tell her whether or not, you know, she was going to get to work. So it really is. It was an eye opener for me. And then when I did interview and go through the interviewing process, again, as an employer, I was just looking to find someone who had the skill set to meet the needs that I had. You know, the last thing on my mind was the credit issue. But I know that it is used sometimes, and I've actually intervened. I know some companies will use it, but as an employer, if I find a good person that really fits, yeah, I understand people go through economic hardships, and I'm going to fight for that person. And I have a couple of times, you know, because of credit history, to say, look, this is a good employee, they'll do a good job, and I vouched for them. So, but again, it is a important topic, and both representatives speak to what they've said. You know, you don't want to use it as the primary reason that would hurt an employer or employee if you pass a law. And then I guess the Representative Hagler, that amendment I think will help you out there. So, would you anything else you'd like to say? We do have another person who wants to speak against the measure. Mm-hmm. So, do you have anything else you'd like to share? I'll let you come back up.
Okay.
If you want to. So.
Okay. Thank you.
You can have a seat there if you like, and we'll just call you back up. Okay. Okay. We do have someone else. Yes, come up and tell us who you are.
Thank you, Mr. Chairman, members of the committee. My name is Roy Bowen. I'm president of the Georgia Association of Manufacturers. And we do have some concerns about this bill as it's drafted. I certainly agree with the comments made by Representative McKillop early on about the employer relationship. I think what we're also doing here is creating a new protected class, and I think that goes well beyond what we need to be doing at this stage. I think this legislation is also very vague. Who determines what bona fide is? That's not clear, and it just opens the door for litigation. And what's especially troubling is the cause of action that this legislation enables. I can see just an immense amount of, we talked about employment law and how litigious it is. This is going to even add to that. So for all of those reasons, we would suggest that this bill not advance beyond this point.
Okay. Any questions for Mr. Bowen? Thank you. Okay, Representative Kendrick, if you want to come back up, what we'd like to do, if you want to share anything else you'd like to say, please feel free.
Well, yeah, two responses to the gentleman that just spoke. He mentioned that bona fide is very vague. I draft contracts for a living. And so while you don't want a law to be too vague, once you start naming stuff or making lists, judges are going to construe that according to that list. And so it actually sort of narrows what discretion the judge is going to have. So it was made vague on purpose, because once we start listing people, then if somebody falls outside their list, they're going to be automatically excluded. The second thing is, will it add to litigation? A lot of the laws that we pass up here are going to add to litigation. And so while it's a valid reason, that shouldn't be the only reason that we don't pass things forward. So that's the only two things I wanted to say.
Okay. This is a hearing. Yeah, if you'd like to say, we need you to come up and tell us who you are. Just tell us your name and who you represent.
Okay. Mr. Chair and members of the committee, I'm Erica Davis. I'm a student at Georgia State University, and I have the awesome task of having an assignment in social welfare policy class to follow a bill that I'm interested in and track it through the legislation process. So far, it's been a little onerous, but I'm making my way through. I'm here in support of Representative Kendrick's bill. Thank you so much, Representative Kendrick. And I come from a perspective, I'll say 3 tiers. As a student currently, as a prior employee of a financial institution where I witnessed discrimination of employees that I interviewed from higher representatives, management, and as an aspiring social worker who will work with all populations that I cannot choose, pick and choose that I will. One in particular I'd like to mention is maybe the gerontology community. But I come because I read the bill and I said, okay, as a student, and all of you I'm sure have experienced this, you've gone to school and you work hard and you get qualified with credentials and classes, and then you come out and you might have had to choose between paying your credit card bill, which they solicit very highly on college campuses, and then you choose food as opposed to paying a bill. That doesn't say that you're not qualified to take a job. It just simply says that you made a bad decision, and I'm not negating that responsibility. However, it happens to all of us. As a employee of a former employee, of an institution for over 15 years, I witnessed how temporary agencies would screen our employees, and they would literally come back and tell us that, oh, their credit was bad. But I was trained as an employee how to look at credit by all 3 credit bureaus, Experian, TransUnion, and Equifax. How do we know the people that were looking at the credit were qualified to do that? And what is bad credit? I was always told, when you're collecting on a bill, a student loan is not necessarily bad credit. A mortgage is not necessarily bad credit. It can turn into bad credit based on your pay history, and so can your student loan, but that doesn't mean it's bad credit. If you have a charge-off, which is an I-9, where you fail to pay the debt and the company charges it off as a loss, and then they have to recoup it later, that is bad debt. It can happen because of medical expenses. It could happen because you had to help a family member who you love and cherish, but they fell onto hard times, and then because you did that, your credit, unfortunately, it slipped. As an aspiring social worker, I'm going to work with the gerontology population one day, and many others, but that's my concentration. And they have family members that they've, again, had to help. Now, they worked hard. They've earned their Social Security. They've had the right to retire, and then something happens. They may have to go back to work because of, not being able to meet their needs for medicine and food. But if they do that, there's a discrimination sometimes because of their age. This bill, if it was passed, unfortunately, would probably hurt them as well. And I don't think that's fair to any of the 3 examples that I've given, that your credit is actually looked at to say, well, I'm a bad person, and sometimes that can happen because, again, it goes back to the people that are looking at the credit, are they qualified to do so? Again, I apologize as a layperson I'm speaking to here today. I hope I've made some clear points. I am in support of the bill. I believe that it would help with unemployment. Georgia has been high above the national. I looked at it this morning. It's still high above the national. The bill is not perfect from what I can hear, but how many bills are that actually go through? And lastly, how many of you, no offense, have perfect credit? And if your credit was used to discriminate against you, would any of you be here? Yes, based on other merits, I'm sure. And again, I hope that was enough, and thank you for your time.
No, thank you very much for coming today. As a former chairman of Higher Education Committee, I'm very grateful that students come and participate in the industrial relations process. Okay, very good. So if you'll work, Representative Hagler and Representative Kendrick, and maybe a committee substitute with the changes that you recommended, we'll be glad to do that. Okay. Any other issues to come before the Industrial Relations Committee? Hearing none, the committee is now adjourned. Thank you.